and I rise to speak to the Fair Work Legislation Amendment Closing Loopholes Bill 2023. I should say that title is a little misleading, because to say closing loopholes ignores probably the much broader range and scope of this legislation amendment, because it is in its essence the second omnibus industrial relation change legislation put forward by the government, which is concerning in that at a time of fair stress on business and uncertainty in the industrial relations space, it's introducing a significant amount of change. And we know in particular for small businesses, increased amounts of red tape, of administrative processes and compliance is incredibly difficult. It really adds to operational costs and puts many small businesses at risk. So this legislation, it is an omnibus bill. It has a huge amount of changes proposed across the industrial relations sphere. The key changes include changes to the definition of casual worker, changes to the definition of what constitutes a contractor, makes intentional wage theft a criminal offence, further empowers the Fair Work Commission to set standards across parts of the gig economy. It introduces reforms to the test for claiming post-traumatic stress disorder so that federal police, ambulance officers, emergency services, communications officers, firefighters can claim entitlements for post-traumatic stress disorder without first having to prove that they have acquired the disorder from their job. A non-contentious inclusion that should be passed quite separately, and I will come to that. Protection for victims of domestic violence from being discriminated against in the workplace by their employers, again, very non-contentious, that should be passed separately. Protection of redundancy payments for workers who might be working for a larger business, where the business has technically become a small business due to insolvency. This is slightly more technical, but again, fairly straightforward and shouldn't be caught up in the omnibus aspect of this legislation. And recognition of silicosis so that it is dealt with in the same way as asbestos under the Asbestos Safety and Eradication Agency, including coordination on silica safety and silica-related diseases. Again, this one I believe would be would have the support of the House, incredibly needed. And again, it raises that question of why such important, fairly urgent pieces of legislation or amendment are being caught up and put in this omnibus style of legislation. And I am concerned that this is a bit of a trend by the Albanese government across a few sectors, and I anticipate there are more legislations of this nature coming. We're quite disjointed and different issues are all getting pulled into one piece of legislation. I believe it's in the hope of wedging those that have issues with certain areas of substance of the legislation, because if you're unhappy with one part, you're then caught up with whether you should be supporting another, and it's really just playing politics instead of looking at the merit of the legislation and particular elements of it. And I should say it's been disappointing this week that the government had the opportunity to deal with those four more urgent aspects of the legislation that have support across this place and that passed in the other place, came back here for consideration. But the government preferred ultimately to play games on those areas of legislation, and where fairly urgent need of financial assistance could have gone to first responders, victims of domestic violence, where payments could have been in effect from 1st of January 2024, they instead will be held up by the remainder of this legislation. The government's stated aims in relation to this omnibus are clear enough: closing current loopholes in the Australian industrial relations landscape to allow that can allow for an exploitation or even harm of employees. There's no dispute that the system is far from perfect and that there are areas of concern that do need closing. But what can be seen in this legislation is taking a sledgehammer where, a hammer to a nail probably would have been enough. And there's the overreach in relation to some of the provisions that is what is causing the greatest concern. The stated purpose, are noble aims, and many in this place can agree with them in principle. And we absolutely want to see fair employment and pay conditions. And we certainly should never see stealing of wages from employees, and these are provisions long overdue. There's no doubt that reform to the gig economy is needed, but how it is done matters. And because we do need to make sure we maintain the flexibility and an ability to have a dynamic business and industrial relations environment so that our businesses are competitive. It is a global marketplace. We see that across many sectors for businesses of all size. And unless they can be competitive, they will ultimately pay a price. So I have urged during briefings, and I would have urged the government to tackle these issues one at a time, individually, so they can stand and be debated and really be dealt with on their own merit. So I do feel that, again, this omnibus style of legislation is incredibly disappointing in relation to such an important area, especially when it's policy changes of such magnitude stuffed into a large bill, which just is not going to bring about the considered policy changes that we should be working on in this place. The bill doesn't pay respect to stakeholders who want to make real and meaningful change in the industrial relations area, and in particular for those that would help those that do need it sooner. I note the bill has been referred to the Senate Education and Employment Legislation Committee, and the committee's report is due in February 2024. So I do have a procedural complaint with the government that it is requiring the bill to pass through this place when we know that it's not the final form this bill will take. And so essentially, following the inquiry, there will be amendments and there will be movement. But rather than us have the opportunity to consider a bill more in a formal state, a final stage, it is a process of pushing it through here. It will get amended, and we don't have the benefit of the findings or of any of the recommendations that will be made by that committee. So I do have concerns about the current drafting of the bill and the impacts it will have on many Australians, employers and employees alike. In particular, the definition of casual employee. The definition of casual and the related provisions introduce a degree of rigidity into the employment environment, which may well have unintended consequences. Small and medium-sized businesses, because of their size, are particularly vulnerable to market fluctuations, and they need to be nimble. And as a result, they need a significant degree of flexibility in their staffing arrangements. So I'm concerned, and the feedback I've received is grave concern around the proposed amendments, that they don't contain the sufficient degree of flexibility for either of those employers or their employees, and that accordingly some of those businesses may well suffer. The rigidity also affects the question of whether workers are independent contractors or employees. The economy, particularly the building and construction industry that many in this place have talked about, but is quite prevalent in many of our communities, already faces significant stresses relating to this issue, and whether workers can legitimately set themselves up and operate freely and flexibly as independent contractors. Another consequence of this reduction in flexibility may well be the risk of businesses knowingly shrinking their workforce in an attempt to ensure that they do not fall foul of these more rigid work arrangements. So what is proposed may well discourage the engagement of casual workers, and that, I think, would be a really disappointing consequences to industrial relations changes. Similarly, employees of such businesses are often attracted to working for them for reasons of the flexibility and responsiveness of those employers to their particular situations and need. And if that is lost, again, that is not a good thing. Warringah constituents are concerned that this change to the definition of casual worker is really likely to result in very negative consequences and not ones that I think are to the benefit of the sector. Warringah is an electorate like many others, I would say, in the country where there's a number of small businesses, and they boast an entrepreneurial spirit amongst many of its residents. All too often, small businesses It is the small business owners that underpay themselves to ensure the viability of their businesses. And whilst we've actually dealt with other legislation to assist small businesses, recognising the challenge they are under, we then have this type of legislation that's likely to make their trading circumstances all the more difficult. The issue also, the feedback from small businesses, is just the uncertainty, the changes that continually occur, the increased requirements, the administrative aspect. It is just incredibly difficult for them as small workforces to be able to cope with the constant changes in an environment where they're feeling immense stress from the aftermath of COVID, where they often incurred increased borrowings to stay afloat. They delayed rents, which are now due and have increased, increased operating costs and reduced consumer confidence in too many situations, and staff and labour shortages. So small businesses in Warringah are constantly telling me they don't need a more complex business environment in which to operate, and this bill does do that on a number of fronts. The gig economy. We hear a lot about the reasoning for the government in relation to the changes proposed, and it is a key aspect and a key area of justification, and there's often the latching on to incredibly dramatic and sad events and accidents that have occurred. But there's a real difference between looking at safety when it's on road safety and then looking at and the link that is claimed in relation to pay. The feedback that I've had from various stakeholders that whilst it's a good in part and that they do welcome minimum standards for gig work, it's a good thing. From Uber to DoorDash, they've expressed such sentiments. But there are concerns within the industry, and it includes the scope of the terms and conditions that could potentially be included in a minimum standards of order, remaining way too broad, leading to significant uncertainty for platforms and the flow-on impacts for gig workers, consumers and businesses. The government could assist with this by providing much greater clarity and direction as to what minimum standard orders and what would be expected of industry participants on this front. They're complex questions that need addressing for parts of the gig economy that deal with care workers. Companies such as Mabel, online platform that connects Australians looking for disability and aged care support with independent support workers, are on the record as saying that the proposed reforms would drive up costs for the National Disability Insurance Scheme and cause workers to quit the platform. So at a time where we have staff shortages in these key areas, in particular in regional sectors, it's hard to understand why the government would go down a course to make it more difficult. I appreciate that on the other side of the argument, recent research from the Australian Institute highlights that care and support gig workers treated as independent contractors are in highly insecure work and without minimum standards. So it's clear that a balance needs to be found, but many are concerned that the balance is not as it's currently found in this legislation. And I would urge the government to consider delay and further consultation to arrive at a better outcome. We do need to make sure gig workers have safe environments where they're not exploited, but able to maintain the flexibility this sort of employment affords to them. So I believe that the Fair Work Commission's power to make orders is too wide. For example, it will be able to make orders for a minimum number of hours worked per shift, which might not align with how platforms such as Uber and others may well operate. The government should take the considered feedback on board and further look at how this bill proposes to change the role of the Fair Work Commission. So I have a number of concerns about this omnibus bill as it stands, and I must say I am disappointed with the approach the government has taken in presenting these style of omnibus bill. We were promised better procedure, better conduct than the previous government, and whilst I acknowledge in some aspects things are better, in others we're seeing much of the same, with really political games being played in relation to very important questions of policy. So I urge the government to take more time to consider complex aspects of policy change, not to overcomplicate the industrial relations sector, because we cannot afford to have small businesses in particular overburdened, and a system that loses flexibility and dynamism, because it is an incredibly competitive market out there, and our businesses need to remain competitive.